Hello, everyone. My name is Lidia Bonifati, and I'm currently a postdoctoral researcher in comparative public law at the Department of Legal Studies of the University of Bologna. And today I would like to present my new book, Asymmetries, Courts, and Comparative Constitutional Law, a dynamic accommodation of diversity in divided multi-tier systems. The book was recently published by Brill in October 2025 within the series Studies in Territorial and Cultural Diversity Governance. Before I begin, I would like to thank Professor Giuseppe Martinico and the team of Comparative for their kind invitation to present the book within the series. It is truly an honor, so thank you so much for having me. In this brief presentation, I would like to outline the three main objectives of the book, with the hope that you will find them interesting and that you will want to read the book. So a first objective was to frame constitutional asymmetries not only as an instrument, but as a dynamic constitutional model to accommodate ethnocultural diversity in divided multi-tier systems. To do so, I conducted a systematic comparative study of constitutional asymmetries in 12 case studies across the global north and the global south. From the comparative analysis, three interesting aspects emerged. First, that asymmetries can be introduced according to different degrees of intensity. This aspect has been already acknowledged by the literature, but not yet empirically tested. The comparative analysis shows that asymmetries can vary not only across case studies, but also within cases. For example, the degree of constitutional asymmetry can be high or medium in one dimension and low in another dimension. This is the case of Italy, for example, where asymmetry is medium in the powers and competencies of subnational entities of the regions and low in the status of subnational entities. Another example is that constitutional asymmetries can be present only in one dimension and not in the other two dimensions. This is the case of Spain, where asymmetry is high only in the fiscal arrangements dimension and absent in the other two dimensions. Or the case of Canada, where constitutional asymmetry is only present in a low degree in the dimension of status and absent in the other two dimensions. So we can see a high degree of variation. A second aspect emerging from the comparative analysis was that constitutional asymmetries were introduced in different settings of territorial decentralization, not only federal states, but also regional or devolutionary systems. For this reason, I decided to employ across the book the term multi-tiered systems precisely to encompass the huge variety of manifestations of the principles of federalism. Finally, the comparative analysis showed that constitutional asymmetries do not belong to a specific legal or constitutional tradition, since they can be found in constitutional systems in the global north as well as in the global south. Of course, according to different degrees. In fact, asymmetries can be found in Eastern and Western Europe, so in Italy, Spain, Belgium, the United Kingdom, and Bosnia and Herzegovina, can be found in North America, in Canada. They can be found in Southeast Asia, in India, Pakistan, Indonesia, Malaysia, and Myanmar, and in the Middle East, in Iraq. So the variety of constitutional solutions adopted by the systems clearly indicates the dynamic nature of constitutional asymmetries, which can provide flexible arrangements tailored to different needs and settings. In this sense, the study showed that the presence of constitutional asymmetries do not entail a prefixed structure. If this first goal was more related to constitutional design, a second objective is linked to the role of courts. Indeed, a second goal of this book was to explore a neglected actor in the studies on constitutional asymmetries, namely constitutional courts. Specifically, I analyzed the case law of 5 courts across 4 constitutional systems. So these are the Indian Supreme Court, the Italian Constitutional Court, the Spanish Constitutional Tribunal, and the Constitutional Court and Supreme Court of Indonesia. The case law analysis allowed me to better grasp the impact of courts in shaping or reshaping the degrees of constitutional asymmetries, confirming that constitutional courts are a very much relevant actor and factor to take into account when studying asymmetries, as they can facilitate or hinder their development in the system. Generally speaking, apex courts tend to interpret constitutional asymmetries as a threat to the territorial integrity of the system, and as a result, they are more inclined to reduce the space of asymmetry than to expand it. The case law analysis also found that courts display a very much changing behavior towards asymmetries, not only over time, but also across dimension and depending on the subnational entity involved. This is the case of the recent decision of the Indian Supreme Court that confirmed the federal government decision to abrogate Article 370 on the special status of Jammu and Kashmir, and so dramatically reshaping the degree of constitutional asymmetries within the system. Finally, a last goal of the book was to challenge comparative constitutional law beyond its comfort zone, combining traditional doctrinal analysis with emerging strands of comparative legal research, such as empirical legal studies and decolonial comparative law. In this respect, I employed the standardized indexes on subnational autonomy developed by Patricia Popolier to measure the degree of constitutional symmetry. And this allowed me to offer not only a qualitative, but also a quantitative assessment of constitutional symmetries. Moreover, I was very much interested in studying the legal manifestations of asymmetries not only in the global north, but also in the global south, acknowledging the role played by colonialism and decolonization in imposing or rejecting constitutional asymmetries in the constitutional systems.